Actually, the driver was
Parents.
no, actually the drivers were driving. It was not the child. The driver was driving. And the child was sitting there. He told the driver, "You should drive." That's the nature of allegations, Lord. These are the kind of things which happen at
My lords, today it's for bail, my lord. Lords, grant us bail, my lords. And please, yes, please say.
No, my lord, what I am concerned and what I wanted to show that the trial is being derailed, my lord. The trial is being derailed.
antecedents.
Let's see page 81. That's what I was showing. They refuse to argue the discharge. They say we will not argue it. Repeated adjournments, my lord, by this Ashish Mittal. That's page 81. This is peculiar of my counter. This is the Roznama of 15/9/25 minutes. Just see the bottom.
Yes.
Considering the last 4 lines, considering the above facts and the fact that the application exhibit 2110 of accused number 9, which is Ashish Mittal, for adjournment is rejected, there appears substance in the contention of the prosecution that the present application is taken out with the intent to protract the matter. As such, the application is devoid of merit. On inquiry, advocate for accused number 9 submitted that he is not going to advance argument today on discharge application. And as to framing of charge, as advocate for accused number 9 failed, then will at the next page. That's a July. That's a
suit out because they are in jail.
will they take a stay from the High Court? Page 90.
The council made a statement.
Page 90.
They are in jail for 1 year.
In jail, how will it suit?
Therefore, will be delayed.
Your part,
And-
1 year, 4 months.
1 year, 6 months from me.
From August of 2024.
Not more than 18 months.
1.
4, he was arrested.
All are about 18 months.
About 18
Page 90. Page 90.
18 months.
Will at page 90 for a moment.
2024.
May of 24.
19th May 24, my lord, is the date of incident.
Therefore, my lord, the delay is at their instance is what my effort is. See page 90.
Can I just show you one
Conditions court. If that
Yes.
can always.
one para of one para of the
Because
impugned
there is a
judgment?
stay
if I
by the
may.
High Court. There is now a stay at Ashish Mittal's instance by the High Court of framing of charge.
The High Court has granted the stay.
Very well, Millard.
High Court has
No,
granted.
Millard. Therefore,
High Court for that.
So therefore, I am saying, Millard, therefore, Millard. No. The submission is. I am not saying, Millard. The submission today is that the plea that trial is taking a long time is not attributable to the prosecution.
It's taking a long time.
Very well. Can I just show you a para of the impugned judgment, if I may, because that's also a High Court. Para 24 at page 26.
Yes.
If your lordships have para 24. From the facts and circumstance of the case and the material on record, it is evident that applicants Vishal Agarwal and Arun Kumar Singh are financially well placed. Witnesses like the private drivers, watchmen, and domestic aid were working with them for a considerable time prior to the accident. Arun Kumar Singh and Ashish Mittal are very close to each other. The hospital staff who are witnesses and were associated with Dr. Halnor to take blood samples, etc., are his subordinates. The student from whom the bribe money was recovered is junior to Halnor. All these witnesses, including Halnor, have been working under Dr. Taware. The statement of the car driver of applicant Vishal indicates that the grandfather of the CCL tried the money power to make him accept that he was driving the car at the relevant time. In the wake of above, if bail is granted to the applicants, even subjecting them to stringent conditions, there is every possibility of their tampering with the prosecution evidence using their money power and superiority dominance. This would ultimately thwart the course of justice in this case, which was exposed to danger soon after the accident. Because, as highlighted by the learned special PP, there was unusual delay in the medical examination of the CCL and his two friends. Secondly, the belatedly recorded statement of Adi Sheikh also hints at that danger. Now, para 29, my lords, for a minute.
But there's a presumption that they will tamper.
I beg your pardon?
There's a presumption.
No, Millard, there is a DNA report that they were tampered.
There's a report. There's a report that is tampered. So, yes.
Blood samples were tampered.
Yes, Millard.
2 passengers.
Just one page.
We're not accused.
Drivers was tampered and 2 passengers were tampered. All 3 were tampered.
Yes, all three were tampered.
They are the parents of the 2.
Millard, this
Who all conspired to save the main juvenile driver.
This is, I don't
The
understand.
minors
Millard,
go to jail.
the submission is that only because their children were sitting at the back can't be a fact yours to their benefit, Millard. Ultimately, the attempt was to cover up the whole thing.
Absolutely.
The trial.
Yes,
Just the direction here at
Without one more
the
thing.
direction at para 29 is
Date from the High Court
that the bail request can be renewed after material witnesses are examined. That's what the High Court has said. Material witnesses are about 15 material witnesses. No, if your lordship going to direct for it to be expedited, then it shall
Charge
be
is not
quickly.
framed.
Case with the UAPA case was.
Well, learned friend is for the complainant. How can he be in charge of the trial?
And charge is not framed, I might be discharged.
If it's only a case of rash and negligent driving, nobody would be opposing it. If you undermine the justice system with corruption, bribery, and money power,
Before that,
which we can hear over here, in a large volume, there's a problem. There's a
Is
problem.
this the case, this is the only case to be expedited? What is this?
Common order.
Grateful.
Learned, we have heard learned senior counsel for the appellants and learned standing counsel for the first respondent state, and you are
I'm for the parent of the mother. I had of the girl. I had been allowed to intervene. Yes.
senior counsel for the pleading applicant, who have all vehemently argued their respective cases.
He's not relevant.
Learned senior counsel for the appellant submitted that insofar as the appellants in, you write, in item 69 and 69.1, write those, are concerned. They are the concerned. They are the no allegation or offense has been alleged against their wards. In fact, the appellant in item 69 is a friend of the father of the child who was in the back seat of the car. And the appellant in 69.1, right there, or whatever, is the father of the child who was in the back seat of the car, which is said to have caused, the driver of which is said to have caused the accident owing to rash and negligent driving, resulting in the death of 2 innocent persons on so and so date. The appellant in 69.2 is stated to be a driver of the
No, Lord,
police driver.
he is just a middleman who allegedly received the amount from the driver of the parents of the juvenile and handed over to assistant of the doctor.
It's not a driver.
No, he's not the driver. Driver is not even made an accused in the case.
If, within inverted commas, middleman who had received a sum of rupees 3 lakhs for the purpose of replacing the sample of blood of the wards of their wards.
One of the walls.
Of the two juveniles who were in the back seat.
He did not replace, he just handed over to the assistant.
That's the allegation.
That is the allegation.
That's the allegation.
Stated to have handed over a sum of rupees 3 lakhs to the
Assistant of Dr. Halno.
to the assistant of doctor,
Hello.
say in paragraph 20, so and so. It was submitted that since there has been no allegation whatsoever as against the 2 juveniles who are in the back seat of the car, it is unlikely that there would have been any kind of attempt made by these appellants for replacing the blood sample of the said 2 juveniles who are in the back seat of the car. However, since the allegations have been made as against these appellants, they were arrested and are in jail for a period of
More
1 year,
than 20 months.
for
More than
nearly
18
18 months. For nearly 18 months. It was submitted that even as against the driver who had caused the accident, the punishment is only up to
3 years.
3 years.
3 years. Even if it is held that it was the juvenile who had caused the accident, the said perpetrator is now being proceeded against before the Juvenile Justice Board. In the circumstances, it was contended that continued incarceration of these appellants in the absence of there being any progress in the trial and possibility of there being